While the answers to questions presented in this program are accurate according to existing law and court findings, they are not a substitute for a consultation with your own attorney, who can advise you with specifics pertaining to your own questions and issues. I am self-employed and have not always claimed all my income on federal and state income tax returns. Can my spouse use this against me in the divorce process?
While your spouse may attempt to use this as leverage against you in divorce litigation, he or she would certainly be ill-advised to do so. The reason for this is that whenever information regarding alleged unreported income is presented to a judge, that judge has the obligation to report that unreported income to the Internal Revenue Service. And if that were to take place, there are certainly devastating ramifications that could ensue. You and your spouse would be subject to interest, penalties, and potentially even jail time. And presumably during your marriage, you and your spouse filed joint income tax returns. So any unreported income she is alleging against you pertains to he or she as well. Luckily, there is an alternative in a situation like yours in lieu of going to trial, and that is going to binding arbitration. And what binding arbitration is, it's just like a trial, except it's going to be in an office setting, and a binding arbitrator could actually be a retired matrimonial judge. So you would still have the benefit of the judicial experience of a judge, but you would be, like I said, in an office setting. There would still be testimony, there would still be evidence, there would still be potential witnesses, and the binding arbitrator would render a decision in your case. So it's just as if you went to trial, but the one glaring benefit for you is that when information is brought to this binding arbitrator regarding alleged unreported income, he or she will not have an obligation to report same to the IRS.